Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hi everyone, I'm Jeremy Goodwin, Head of Pensions at Evershed Sutherland. Thanks for listening to Pensions in a Pod, a podcast where we take a look at the latest development of the pensions world. We want to try and share with you as our insights into what we believe really matters, what's really going on here legally. Delighted to be joined today by Jen Miles and Stuart Earle. I'm going to be chatting today about the latest developments in the Virgin Media case and the government's proposed solution to it, and what else is coming over the horizon, and frankly, what all schemes and employers should be doing now in light of the proposed legislative solution that we've got out there, to try and think about next steps and what else might be coming up. So I'm going to do a bit on the background, and then Stu's going to be picking up where we are on the legal fix. Over to Jen to talk about case law developments and other bits and pieces which are out there on the sort of regulatory landscape, and then back over to me to try and pick up next steps. So a bit of background first of all. So going back in time, for those that don't remember, schemes that were contracted out of the second state pension were required to meet what was called the reference scheme test. And whenever you amended a scheme's rules, that rule needed to be certified to have a confirmation from your scheme actuary that the reference scheme test was still met. And what the Virgin Media case was all about was actually, if you can no longer find that confirmation, you don't have evidence of it, you don't have the actual confirmation itself, what does that mean for the deed? And the law was pretty clear, actually, at the time. It said the deed is void if that's the case. And that's what Virgin Media held, that actually, if you can't find the evidence of that confirmation, then the deed is void. And that applies whether these are future service benefit changes, whether the alterations about improving benefits. If you can't find your confirmation or satisfactory evidence of it, then the deed is void. Now, that caused significant consternation, obviously, across all of the industries. This is a big issue, and it's something which we've therefore been doing a lot of lobbying to the government, a lot of different players across all the industry trying to say we've got to do something to fix this, because the value of this is really, really significant in relation to not being able to find those bits of paper, which just show that the confirmation was obtained in relation to those deeds. So that's the background. We've got this case that came through, big issues, big numbers attached to it. So over to the government and saying, please, 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 can you help us? Stuart, what happened next?
I'll take you back to the lunchtime of Thursday, the 5th of June this year, when somewhat bizarrely, I was sat in a school car park flicking through my emails to find out actually the government were going to do something about this.
As you do.
Yeah, well, completely. What else am I supposed to be doing at that point in time? But all that lobbying has come to fruition in a way to find what is possibly a sensible and welcomed solution for the industry. That there are some bits that still need to be worked through on it, and we can chat about that in a bit perhaps. But in headline terms, there is now a proposed solution which is through via amendments to the pension schemes bill, which have been tabled by government in the last few weeks. And in a nutshell, you can look to validate amendments which, as you say, Jeremy, have been made in the past, questions as to whether or not they are valid or were they potentially void. But in fact, these changes through legislation will enable amendments made in the past to be deemed valid and be effective, provided that certain steps are taken and certain conditions are satisfied. So just briefly on those, first of all, the amendment itself that's been made must have been one which was subject to require a certificate at the time. So Regulation 42 or Section 37 certificates, as they're known, would have otherwise bitten on that particular amendment. So you have to get through that gateway in the first instance. And if you do so, and that amendment would have been subject to a certificate, then you have to be able to be comfortable that the trustees have always treated that amendment as a valid alteration. And that's quite important, so that you can't have been in a position where there's sort of any concerns or any question marks about what amendment that was made. It has in fact been applied and implemented consistently by the trustees. And that's also connected to the third limb, which is the trustees must have taken no positive action on the basis that they thought the alteration was void. the legislation, proposed legislation, does have a definition of positive action in this respect, and it requires trustees to have already told members in writing that this historic amendment was void, or taken any other step in relation to the scheme administration in terms of thinking that past amendment was void. So I think in some instances there will be a question as to what's happened over the last couple of years since the first Virgin Media case, just to ensure that trustees haven't actually or inadvertently taken something that could be deemed to be positive action in respect of the alteration. Because if that had done, then that could well take us out of scope for these retrospective amendments being declared valid.
Stuart, it's a really good point.
Yeah.
Can I just come in there? So in terms of, so we've got a number of schemes where we're aware that they've gone out to their membership to say, look, we might have an issue here. So it's to say, it's not to say we definitely do and the thing's void. So they're not saying that, but they are saying, look, this case has come out there and it means that we might have an issue in relation to it. And actually some of them I think have even gone further than that and have said, look, this might be an issue, and then a deed done of, to the extent that it will be an issue in the future, then we're going to kind of cap it now. We're going to cap our liability and responsibility here by having a deed that says, look, if it turns out that that was void, here's something else, which means that actually we've capped the liability and responsibility in relation to this. I would sort of stop the issue at that time. What do you think, Stu? Is that something which is positive action? And Jen, I'd be interested in your thoughts too.
Yeah, I'd be very interested in Jen's comments on that one. But I think, look, that is probably in the margins, isn't it? Because any sort of communication with members beyond the, look, we're aware of this case, we're looking into it, sort of style of communication does maybe get us into an indication that there is a problem or could be a problem. Now, I think we'd want to be very clear in terms of what the legislation looks like. If that's a definitive statement to members in writing that something was void, I don't think that's, that's clearly should be caught, and therefore you couldn't look to validate the amendment. I think looking at trying to take, if you like, sort of a safety net approach to catch a position, and then there's a question of you're not actually taking a step in relation to scheme administration itself because you've not altered anything in response to the historic amendment, you'd like to think would keep you on the right side of them being able to use these provisions to validate the amendment. But I agree with you, that there will need to be a bit of thought given as to, or over the last 12, 18 months, particularly because of pressure that's been brought perhaps onto trustees, but also corporates from auditors in terms of being able to make statements as to what they think is the case for their scheme. But Jen, you're much better placed in terms of thinking about what the evidence position might be, or where the claim might come from there.
Yeah, and perhaps Jen, before you just bring, so I think there's that, and the other one which I'm aware of on this positive action point is stuff in accounts. So there's been loads of so the auditors have been very hot in relation to all this and have been requiring quite strong statements to go into the accounts in relation to this. So again, from your perspective, how broad do you think that concept of positive action is?
So I think it's going to be fact specific in each case, and it won't be one size fits all. But I do think Stuart's point about you're just protecting your position or putting in place a safety net whilst you investigate isn't the same as taking affirmative positive action. But obviously each case you'll have to look at what steps have been taken. And I would be surprised if many people have made definitive affirmative statements at this point. Most that we see are, we're investigating if there is an issue.
Yeah, thanks, Jen. Okay, Stu, over to you.
Yeah, so the other approach to this, if you get through those conditions, those criteria, then you need to make sure your actuary is on side, because you will need to ask the scheme actuary to provide a form of confirmation, similar to as would have been required at the relevant time. And in that certificate, the actuary needs to confirm that in there it's reasonable to conclude that the alteration wouldn't have prevented the scheme from satisfying the reference scheme test. So effectively taking a stance now, taking a position now that would have been taken 20 odd years ago when that particular amendment was made. Clearly, though, time has moved on. The approach that might have been taken initially, the same level of data won't be available. So the draft amendments do allow an actuary to take what is deemed to be any professional approach in order to give that certification. And that includes making assumptions or relying on presumptions, presumably around things like data and the member detail that would have existed at the relevant time. And the actuary can take that view based on the information available to them at this time, provided they consider it sufficient for them to reach an opinion. Where does this get us? I think, frankly, until we see the guidance from the actuarial profession as to what they will need or what is an appropriate approach to take to give these certificates, we're not going to be too much further along the line. Conversations with actuaries to date have indicated that, yep, there's going to be a bit of work to do. They won't be drawn on things until they see that guidance. But actually, as somebody pointed out to me the other day, well, if I've got 5 or 6 amendments, do I have to do 5 or 6 certificates? Can I not just do one blanket certificate that says, well, this scheme is okay and would have met this reference scheme test in all circumstances? I think that's a fair point. At the moment, it looks like you have to do this piecemeal rather than having a blanket exemption for the entire scheme. But again, let's see how things develop, but certainly a focus on that actuarial guidance.
Thanks, Stuart. It's helpful. Jen, what else is out there?
So there is a very interesting case which lots of people are waiting the outcome on, called Verity Trustees, which was heard earlier in the year and on which judgment is expected shortly. So this case relates to the validity of historic amendments related to the pension trust scheme and some underlying schemes. But following the judgment in Virgin Media, they actually added several questions regarding the requirements of Section 37. And those are awaited. And it's helpful to just have a quick summary of what those issues are and potentially how they might interact with the sort of points that Stuart just covered from the legislative fix. So the 6 key ones. One is, what is the scope of Section 92B rights? Should it be narrow, just limited to benefits that are relevant to the Section 12B test? So things like retirement age, accrual rates, or should it be very wide, covering all pension rights, including those outside of that? Should it be up to the scheme actuary to decide compliance on that point? Second point is, did an alteration to close a scheme to future accrual require a Section 37 certificate? This one's been highly discussed by a number of people, and on one side there's an argument that that doesn't affect your Section 92B rights, but there's also an argument that you might have needed to have the surrender of the contracting out certificate before the closure could take place, because reducing accrual to 0 is a change to those rights and therefore required compliance. Third point is whether there's any implied limitation in relation to Section 37. Should it only apply to amendments that could cause non-compliance with Section 9 of the Pensions Act, or should no limitation be applied because the legislation already provides for certain exceptions? Fourth point is, can an invalid amendment be saved by an actuarial confirmation at the next triennial valuation? This is the one that's often debated as well. Yeah. And obviously, on the one hand, there's an argument that yes, it can, and on the other hand, no, that it needs to be at the time. And then finally, there's a couple of questions about whether the court can rely on the presumption of regularity or whether there could be partial validity of the amendments. So lots of really interesting points out there that are weighted. Query, will the parties to that case ask the court not to give a judgment in light of this proposed legislative fix? We don't know. So it'll be a case of watch this space, but it will be highly weighted.
Thanks, Jen. I think we're expecting sometime next month, is that right? So sometime October for the judgment? Yeah,
it should be in the autumn term, but obviously it's up to the judge when that date finally lands.
Okay. So thanks, it's useful. And so in terms of the draft legislation, so it's part of the pension schemes bill, so expecting that to come through next year, so kind of mid next year for it to come through. And so other things that are out there. So obviously we've heard about the Verity case, we've heard about actuarial guidance. There is power under the pension scheme bill provisions for regulations to be made. So to the extent that Verity Trustees doesn't give us the kind of solution that we want, for example, in relation to a scheme closure deed, then keep your fingers crossed, but maybe we might get regulations which would address that as well. The other big one which we're aware of is transfer deeds, and whether transfer deeds should have had Section 37 certificates. Again, keeping our fingers crossed that the actual guidance is going to deal with that. We need the actual guidance to say that a transfer deed can be treated as an alteration, and therefore that the statutory solution can apply in relation to transfer deeds. But again, we'll just wait to see in relation to that. So in the meantime, I think all that great work that has been going on across the industry about trying to go through the deeds and trying to RAG rate them, so red, amber, green, trying to work out what's definitely okay and what may be more problematic makes sense for the time being. Personally, I'd be sending nothing further out to members or doing any further deeds on this for the time being, just so that you keep it nice and clean in relation to that positive steps point. We want to make sure that that statutory solution continues to be available. And one last thing, just for your radar, schemes that are wound up by the time the regulations, by the time the law comes into force, are automatically treated as being okay for Section 37 purposes. So in relation to some schemes that are very close to wind up, they're just aware of that timing, and it's something for them just to be thinking about whether it is something which should be material for them in terms of that timing for when to wind up the scheme. So there's some thoughts. Hopefully that's been useful today. Any thoughts and comments, please obviously do send them through in the normal way. And otherwise, we look forward to speaking to you soon in the next Pensions in a Pod. Thanks all for listening to this latest Pensions in a Pod episode. To access previous episodes, please have a look at our website, on Apple Podcasts or on Spotify, where you can find them all stored for your enjoyment. We look forward to coming back to you in a month's time to give you the latest insight on what's really going on in the legal pensions landscape.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.